Hello, I'm Alistair Craig, General Counsel of State Trustees, Victoria's public trustee organisation, and I'm here today with Belinda Wilson, President of the Law Institute of Victoria, to talk about elder abuse. Welcome, Belinda.
Alistair, thank you so much for having me today to discuss what is such an important topic, and lawyers can help with the prevention of elder abuse. We all know that elder abuse comes in many forms. It can be financial, emotional, psychological, physical, neglect, and even sexual abuse. What we seem to find is that the most prevalent form is financial abuse, but it's also coupled with usually another form as well. What is the hardest thing that we see is that this form of abuse, it is family violence, but it is also usually perpetrated by someone that member really trusts within their own family circle.
There's certainly a need for us to do more research to help us understand elder abuse, but the research we've done to date indicates that 1 in 5 people has knowledge of someone that they think has been subjected to elder abuse. 1 in 25 older persons has actually experienced personally some form of financial elder abuse, and 4 out of 5 cases of elder abuse have involved a family member as the perpetrator.
And those figures are so high and so scary.
Yes, so given those numbers, I don't think we can downplay how complex an issue this is to address with clients. There obviously are ways in which financial elder abuse can be remedied through VCAT, for example, appointing an independent administrator, but often that might be too late. The funds have already gone, so recovering them might be quite a challenging exercise. At least you can put a stop to the abuse that's happening. So in this context, what should lawyers do, and in particular, what should they do if they suspect that a client of theirs is being financially abused?
There's so many things that the lawyer can and should do. So in the preventative stage, it's having that discussion with your client to ensure that, 1, they have a power of attorney. If then you suspect that they may be the victim of some form of abuse, advising that there are certain changes to the law that allow VCAT to step in for powers of attorney. Also too, you need to have a good conversation with your client. Conversation alone, not with their immediate family members. As a lawyer, you should also take really good and comprehensive notes. As lawyers, we also have to remain vigilant. That's one of the most important jobs for us. We also have to remember our obligations under the Solicitors Conduct Rules, in particular, in this case, Rule 8. Now, Rule 8, we have to follow our clients' lawful instructions and competent instructions. So that's really a 2-stage test for us. We can't, as solicitors, do anything that would be unlawful. And we also have to ensure that our client has capacity. Now, under common law principles, we have to presume that our client does have capacity unless there's evidence to show to the contrary.
I couldn't agree more, Belinda, and let's talk about some of the planning that people can do to put in place formal documents that help protect them from financial abuse. Enduring powers of attorney, having a will in place, thinking about these in advance and making sure you're clear on your preferences, what your wishes are. Let's talk a little bit about the important obligations on lawyers in this circumstance.
Of course, there's so many things for lawyers to think about, and one of those is Rule 11. Now, Rule 11 is for lawyers to avoid conflicts between 2 or more clients. So that actually means, as a solicitor, we shouldn't be acting for those that are appointed under a power of attorney and the principal, so that person that is giving the powers to someone. As lawyers, we should also be mindful that we should see the client by themselves, take full and proper instructions, and if we have any questions, such as if language is a barrier, you need to investigate all of those avenues first. Often as a lawyer, we forget the first question that all of us should ask. And that first question is, who is our client? Who are we acting for? And we have to act in the best interests for that client. That client may give us instructions that we don't agree with. We might think personally they're silly instructions, but it is our job, provided they are lawful and they have capacity, it is our job to follow through with those instructions. Going on with the next rule, that's Rule 12. So Rule 12 means as solicitors, we should be mindful not to let our personal interests get in the way of that of our client. So there's been some significant changes in the recent months around solicitors acting as executors for wills. It doesn't prevent us, but we need to ensure that we cover off our obligations under Rule 12, and that's proper disclosure to our clients. We also have to be mindful that we have these conversations with our client so they fully understand our obligations and our obligations to our client as well.
They're really important things for lawyers to bear in mind. So where can they go for more information if they need it?
There's so many places that lawyers can go for information. My tip would be to start with the LIV website. We have a dedicated ethics hub. We also have a dedicated telephone line where practitioners can ask ethical questions. We also have a working group that can assist fellow practitioners with capacity issues. We have the capacity guidelines as well, which is a must for all practitioners. And our website gives a lot more information as to other touch points as well, where the profession can seek that additional information.
So some of the key messages are that elder abuse can be reduced by early detection, and that community education and education of lawyers to be aware of the signs of elder abuse is going to go some way at least to reducing the incidence of elder abuse in our community, and the lawyers have an important role to play in that regard.
Certainly we do, Alistair, and thank you so much for having this conversation with me, because lawyers, we should and can play such an important role in the preventative stages of elder abuse. For more information, you can call the LIV on 03 9607 9378 or email at ethics@liv.asn.au. You can also contact Certified Practicing Accountants Australia, Victoria Police, Seniors Rights Victoria, the Department of Health and Human Services, Justice Connect, the Office of the Public Advocate and State Trustees.